Contesting a will in California is serious business. The first thing I would recommend someone do before they decide to contest a will is read the document and find out if it has a in terrorem clause. In terrorem is just what it sounds like, in terror. It's a no contest clause, means that if you contest the trust, if you say that it's not valid, you get nothing. And so those are sort of disfavored in the state of California, but if you plan on bringing a no contest clause, the first question you're going to have to answer is, does this make it possible that I will be completely disinherited if I bring this matter forward? So that's sort of step one, a preliminary matter to consider when reading the document. But that being said, there are so many seniors in the state of California who are easily victimized by the people who have access to them, whether it's a caregiver or I've seen religious groups who come to their home or a neighbor. All of a sudden you have a person who's popped up on the scene and now they're there at the senior's house all the time. They may start isolating them from other friends and family, and wouldn't you know it, become the beneficiary of that person's estate. And so that's not uncommon. And so those people may pick an attorney, an estate planning attorney, take the senior to the estate planning attorney, and the whole way to the estate planning attorney's office, they tell the senior what is supposed to be in their estate plan. And on the whole way home, they double check to make sure that the senior carried out their wishes and put them into their estate plan. And so if you're a family member or a friend and that happens, what do? Well, you obviously contact a trust and estates attorney, a probate attorney, and show them the documents that you have. There are some basic grounds for contesting a trust or a will in California. And the first one that I want to talk about is undue influence. Undue influence is when someone who has a close relationship with the person, usually a senior, exerts their own wishes onto the senior, and they supplant the senior's wishes with their own. The senior isn't free to do what they want. They aren't free to make the plan that they want to make. They are only going to make the plan that the person in that close relationship with them tells them to make, because they are unduly influenced. People believe sometimes that undue influence comes through threats or through physical coercion, which unfortunately sometimes it does. But it also, and it's interesting because the law recognizes this, it also comes in the form of love and affection. And so you can have somebody say, I'm the only person who loves you. I'm the only person who cares for you. Your family doesn't care about you. Those are other tactics of people who are engaging in undue influence. They're gaining a closeness to the person through love and affection, but for the purpose of gaining access to their estate plan. And something that goes sort of hand in hand with undue influence oftentimes is lack of capacity. And so we'll have someone who has dementia, they, or they're incompetent, or perhaps they have real pain and they're on really heavy painkillers to manage, deep pain, but for whatever reason, they don't have the ability to understand what the document is that they're signing, or maybe they don't know who their family members are, or they don't have the requisite capacity to understand what they're doing. That is another ground for asking a court to set aside a will or a trust. Another ground for setting aside a will or a trust is fraud. If somebody puts in front of a senior, let's say, a document and the senior can't see very well, they say, oh, this is a contract so that you can stay in your nursing home. But really, it's not. It's a will that they have them sign, but they can't really see what they're signing. That could be a form of fraud. And so outright fraud is also a ground for setting aside a estate plan, a testamentary document. Another, and these cases are so amazing when you see them, and you do, another ground is forgery. And that's where someone just forges the senior's signature. So in a will in California, it does not need to be notarized. And so the will does usually need to be witnessed by two people, but those two people could be part of the scam. And so because it doesn't need to be notarized, a will, then somebody could easily forge the signature of the of the testator, of the person making the will, and make a fake will. And so in cases like that, you would get a handwriting expert. The handwriting expert would look at the handwriting of this person, and they could offer testimony that the signature was fraudulent. In the case of a trust, most trusts are notarized, and so the notary provides an extra level of protection so that you don't have forged signatures. But even today in California, a very common crime that's occurring is that people will get replicas of a real notary stamp, and they will use that stamp and they will notarize things even though they are not a notary. And so people involved in these sorts of deceitful actions, they're very clever and sophisticated oftentimes. And so forgery, it does happen. It's absolutely something to look out for. This ground for setting aside a trust is just a reminder of why you should use an estate planning attorney to prepare your estate. The law is very formal, especially with regard to typewritten documents. And so if you have a will, for example, and it does not comply with the rules of wills in California, someone can come to court and say, "Court, this will does not comply with the rules for wills. It doesn't have the right number of witnesses. It isn't signed in the right place." Whatever the rule is that they say is broken. And then the court can consider whether or not they want to throw out the whole will because of that. For in the case of a will, the court has the ability, there's called a harmless error rule. The court can say, "Okay, you didn't follow the rules exactly, but we think that this is really what you wanted to do, so we're going to let it go forward." But the law has not changed to add a harmless error rule for trusts. So in the case of a trust, if there are errors that you do not comply with the strict rules regarding how trusts are supposed to be executed or amended or make changes to, if you don't comply with them and people go to court, then those documents can be thrown out and they won't be effective. The last ground for a will contest is revocation. You simply say, "I know you're putting forward a will from 1989, but they also made a will in 2020, and I know that the 2020 will revoked, superseded the prior will, and this is real." Or somebody could come forward and say, "I have a photocopy of a will, and I can't find the original, but I know that this is their real will." And the party who doesn't think that will is valid can say, "No, I know they took that will home and tore it up. It was revoked. That's why there is no will today." And so all of those matters with a will contest, you would need to seek the advice of an attorney about the basis of your claim, how to present it to the court if it, seems to have merit, and what the timing of that action should be. It's Attorney Amy. I hope you liked that video. Please remember to like and subscribe and hit that notification bell for more content like this. I post every week. If there's topics or issues you think I should cover and you haven't seen a video here yet, please let me know in the comments.